All right. It's hello again. I think we're getting there. All right. Benny Goodman, handful of keys. What are we going to talk about today? I'll try to look in the camera, but I got a little bit going on here. It's like you cannot move forward because we're in the middle. I mean, this channel can't move forward. We're in the middle of talking about Alice DeLau's defense of why Secretary Pechacek's involvement in the Novak case is excusable. Okay? And there's a parallel case, or I shouldn't say parallel at all. Forgive me, I'll just do that. This is a case there that Department of Corrections, Pechacek, and Carr, the decision makers, we sort of been through all of that, the essay, and so forth. Okay, so this is in front of a different judge, and at least, so that's something. And we've gone back and forth, and let's say there has been quite a bit of the government has come and said, both Secretaries Carr and Pechacek has gone to Secretary Pechacek's subordinate, and I want to be clear, and we'll explain why that is. Gone to that person and said, hey, you've got to protect us from being deposed by Ben. That's essentially what's going on here. Okay. So we responded to all of that, and now they got a chance to respond. There's two issues that were going on there. One was the judge was saying, hey, you should know that this case is moving forward, so you should just know to respond within less than 24 hours. And that I thought was pretty strange, or certainly unexpected. I think we can definitely say that. So that was one issue. And then as all of this was going down at my 4:30 deadline, at about 1:30, I get an email from the administrative law judge, meaning a hearing examiner or an attorney who works for the governor, depending on how you want to look at it, saying that, the night before, the subpoena that I think we had put in motion Wednesday of last week had finally got to the secretary, and they sent an email saying it was a bunch of it was terrible and it was all wrong and we didn't follow the rules and we should have done something else. And so, okay, hey, I don't know why this guy's writing a letter to them. It's usually if you want something and you say it's wrong, you want a motion to quash, then you would file a motion to quash. But it wasn't a motion to quash or anything. It's just an email filed by this attorney working for Secretary Pechacek. Okay. So, again, 1:30 the next day, I get an order quashing the subpoena against Pechacek. So I say I'm fairly surprised that you would, quash this order, quash this subpoena here from your boss against the rules. And that those rules were, you need to give me an opportunity to respond before you do something. Let's say that was a motion. Fine. But I need a chance to respond. What if they say the sky's green and I point out the sky's never been green, just for example? It's happened. We've seen what that is. But that is why we say the sky is green, because it goes back to that moment in the Novak case. Okay. So I think it's perfectly reasonable to point out, and we'll continue to point out, that Secretary Pechacek is the ALJ's, and I keep saying supervisor, and one of my colleagues said it's a superior, and my feeling is that because there's a word for direct supervisor, that means that there are other kinds of supervisors. To say your manager's manager is also your supervisor. That's the CEO of the company, in theory, or the superintendent of the school district is the supervisor of everyone. That's the way I use that word. If you got a different understanding, let me know. The way it works is this. There are laws in the state of Wisconsin that say that there is a Department of Workforce Development. There's a law in the state of Wisconsin that says there's a division, an equal rights division. Okay, it says that the Department of Workforce Development, the secretary has all of these powers. One of them is including the management over the Department of Workforce Development. And then it says there's a division. And if there's a division and they do separate things, for example, the Law Enforcement Standards Bureau is attached, just so happens to be attached to the Department of Justice. Okay, it easily could be attached to consumer protection, just for example, or I mean almost anything. Okay, Department of Corrections, easily, but there's a policy reason, whatever it did. The whole concept of that is just because a agency or something is attached to a department doesn't mean that it's true. It doesn't mean that the department speaks for that in terms of policy, in terms of anything else. But unless it says otherwise, is what the rule is, that the secretary is still the manager. So what does that mean? That, just for example, the ALJ, they are in a section. There are at least 3 different divisions. There's sections within the Equal Rights Division. One of them is the investigation. Then there's another one that does hearings. Okay, each one of those has an director. They're bureaus. Bureaus, of course, have directors, as everyone knows, and these bureaus naturally have directors. So the director in the chain of command, and gosh dang it, we don't have it here. Magic of pausing. Oh, Jello again. All right. So through the magic of radio here, we have and Debbie Keither, and the Department of Workforce Development, we have their organizational chart here. So we can see above here is the Secretary Amy Pechacek, bam, her Pamela. Yeah, okay. Yep. Then we look down here. This is the Wisconsin Employment Relations Commission. It's attached administratively. Okay. But you do not see, here we go, the Equal Rights Division. Direct line. Then we go to Bureau of Hearings and Mediation. Should we look there? Bureaus of Hearing and Mediation. Bam. Under there, the bureau head is Maria Selsor. She's an attorney. She's an ALJ. She's the bureau director. Guess who appointed her? Amy Pechacek. Bam. Now let's go to the Equal Rights Division. That, of course, is headed by an administrator, because administrators administrate divisions, as everybody knows. That's as natural as nature. So Ramona Natera is the newly appointed Equal Rights Division administrator. And guess who appointed her? Well, shucks, it just so happens to be Secretary Amy Pechacek. So I will see what they have to say on that issue. They've written me they've written a new decision saying there's no conflict there. I haven't really, we'll cross that bridge when we come to it. Okay. Jello again. So we're in there. That's, I would say, that's the reality. That's their reality. Okay. I mean, that's what they tell the world. They may have some other concept. We'll see. So, but as we say, I think we possibly broke the ERD here while dealing with this issue. So again, Secretary Pechacek files a motion with the ALJ, 4 levels down the food chain, saying, let me out of this subpoena for Friday. By the way, she should not have to go to that subpoena on Friday. That attorney should have simply just called me up and said, hey, Ben, we got this subpoena. We're obviously going to need to not appear on this date because we've got X, Y, and Z thing. And that would have been fine. Guess when I first went to Secretary Pechacek October. And, of course, they're coming to the judge saying this is the first we ever heard of it last minute. This is ultimately, it's like outrageous and so forth. Did she ever respond to me when I asked her when she was free in November? No. How about when I went to her attorney? Did the attorney ever respond? No. The attorney's on the filings now saying I filed this at the last. Because I didn't file anything. They filed this protective order. And again, here they're accusing me of waiting till the last minute. But they've got a different agenda. So, again, I say, Judge, you've got your supervisor filed a motion to quash, and without hearing from me against the rules, you granted their motion. Another thing that would have been perfectly fine to do is just call me up. The judge could have just called me up or got all of us on the phone. All of these things could have been settled fairly easily. With due process, meaning the client gets a chance to be heard. That's just fair. That's how it is. And guess what happens to be the ERD's rules? So then he sent me a communication basically saying that he took umbrage with that line. And I said, well, let's again look at the facts here. Then we went over the law, chapter 15. And then we went over the rule that requires, it says somebody files a motion, the other person may respond. He says, you didn't, with less than 24 hours, you didn't respond, and I didn't tell you to respond. And so normally how this goes, by the way, just so we're all clear on what the baseline expectation is this. In federal court, it's basically like this. So-and-so files a motion of just a regular old motion. The other side has 15, 20, whatever the X amount of days. Do not quote me on any of those ones. Because it varies for this and the local rules and the da-da-da-da-da. Okay. The other person has so many days to respond. Boom. The first person who files the thing gets a reply. Boom. All those things happen, boom, 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 within such and such time. If you do not say pretty please to the judge, let's say you get in a car accident and you don't immediately file a pretty please, can I get a good an extension or whatever it is, you've got a big problem. And that's it. The judge makes a decision when they want to. They might call a hearing when they want to, and that's how it goes. In state court, normally, the way around me, it varies, especially with COVID, again, but the concept is this. Person wants to file a motion. They call up the court clerk. They say, hey, I want to file a motion. I'm going to need a hearing. Oh, the court says, that's interesting. How long of a hearing is it? I probably will need an afternoon. A whole afternoon? Yeah, probably a whole afternoon. Okay, well, I can't get you on the books until such and such a date. Okay, thanks. Great. Have a great day. Have a great day. Boom. So you got your date. You then take your little motion that you would have filed anyway. You take your note and you file a notice of motion with the date that you have in there. You send both of those things to the other side. Here's the notice of this motion that I'm filing. Here's a motion, okay? And those things do two things. It tells sometimes you can file a letter, and it could be asking the court for something. That's not really a motion, but it can be treated like this one. That's why it gives you that opportunity there. The whole concept is you can't say you didn't have a chance to respond. Then, going back from that date, 15 days, 30 days, whatever it is, you've got a chance to respond to the motion. Then on the day of the hearing, the judge hears whatever, makes a decision either then or whenever the hell they want. That's how it works, okay? In the ERD, it's a little different, meaning any judge makes a decision on whatever deadlines they want whenever they want to. There's no rules. There's just this one line that says that ALJ can do the course of the hearing. So sometimes they will say 3 days, and then I say, like, you got to be kidding me. This guy said less than 24 hours twice now. Okay. He's got good reason for that. The holidays are coming up, I guess. The holidays are different for everybody. But hey, but the whole point of that is, to be fair, everybody needs to be heard, and to be fair to the people to respond, they need to know what the issues are, and they need to know when they have to respond to those issues. That's fairness. So when you don't know, if somebody just sends an email saying this subpoena is garbage, and then the judge acts on it, that's not really notice. That's problematic there. Okay. Right? And that's, if we look at the Delphi sort of case on what's going on there, part of that issue there is they're getting pushed out on this, summoned to this hearing, and there's sort of this emails back and forth, or sort of discussion back and forth on what is, should these guys be disqualified and kicked off the case? And their number one thing is, well, if you want to argue that, that's fine, but we need a chance to respond, and to say show up to this hearing and we don't even know what this is about and the other guys got evidence ready, that's not really fair. That's a very similar argument. Okay. So, again, here's the law. Here's why she's your boss. Here's the rule that says I may reply. Doesn't say when I may reply. I get that it's not, but it's certainly, if I don't respond with less than 24 hours, I lose my right to reply. Okay? That's what he says. He says the attorney, and this is, intentional language, for Miss Pechacek, filed a motion to quash the subpoena, which was improperly served and premature given the fact that there was an objection to Miss Pechacek being deposed in the first instance. All of that may be perfectly fair. And in fact, I'm not going to argue any of those here now, but in fact, that all might be 100% perfectly true. But we still may have a response to that. We might. Okay? That could be true, and the response still might not be to quash. Just for example, just going to put that out there. Okay? Under DWD 218.15 sub 2, this is the one, this is motions have to be written, and the opposing party may respond. You could have responded, but didn't. As previously noted, I have been trying to resolve these issues as quickly as possible, given the approaching discovery deadline of December 18th. In addition, we are approaching a period when many people are away for the holidays. Time is of the essence. You should not need to be prompted to respond to a legal filing involving your client's case. Okay? You see how that may not really answer the real question, as the prompting. Again, we do need prompting because an email is not a motion. And we do need prompting because my imagination about what the judge might be thinking for a deadline is not really notice. It's not. I mean, under that rule, I can just keep filing things all day long and endless replies. The end, because the judge might possibly want to hear more from me. I mean, there's a lot of reasons why that doesn't make any much sense, and certainly isn't in accordance with the rule. I could have responded but didn't. There's a lot to unpack there. I hope he did it. Okay. Now, I just want to go here, and this is what this whole thing, this is what I'm unpacking here, and this is why we're doing this together. So, as you may recall, there is the Equal Rights Division. We've explained this. This is and then there's federal court, okay? And for different reasons, we have more access to show you what's going on at the Equal Rights Division than we do at federal court. Some of that is the rules of the two institutions. Some of that is the cases that I have. Some of that is, there's just a lot of, meaning sometimes I have permission for some cases that I don't for others. Some reasons are more strategic than others. Some things need to be shown. The kinds of cases that go to the ERD may be more likely to be, I mean, I could go on and on and on. Anyways, one can almost always basically quit the ERD at any time, including during the hearing, and then go to federal court. Absolutely the case, okay? And this is now the second time that this has happened to me, where I've gotten a form that was from the judge here, and I'll explain to you what this form is. And here it goes. Attorney Cross, if you are so concerned with the notion of a, quote, conflict of interest, close quote, regarding Amy Pechacek being the acting secretary of the Department of Workforce Development, DWD, the umbrella organization, which I'm sorry. We're going to start that again. If you are so concerned with the notion of a conflict of interest regarding Amy Pechacek being the acting secretary of the Department of Workforce Development, DWD, the umbrella organization which includes the Equal Rights Division, ERD, then dismiss this case, parentheses, and any other case for which you perceive a problem, close parentheses, and take the case to the EEOC. The case was cross-filed with the EEOC and was issued a case number. Oh, he even provided a case number for me. Thank you so much. I am attaching a withdrawal form for you to fill out, sign, and return to you. To me, I will issue the dismissal order as soon as I receive your signed withdrawal. All right. So that's due process in action, as they say. There we go. I can tell you exactly how that made me feel, but I'll save that for some other time. Why don't you tell me how you perceive that to be? As we say, I think we still say that, right? I think we have music. I think we can still, music, animals are out, music is in. Can we still say, stick with us, we'll keep you informed? Can we, I hope we can do all those things much of the time. Thank you. Have a great day.